Hey everyone, I'm Veena here. In today's video, we are going to see about Advocate Protection Bill of 2021. Before entering into the video, please do subscribe my channel. Firstly, we will see what is the bill about. The draft Advocates Protection Bill is aimed at ensuring adequate protection to members of the legal fraternity so that they can carry on their duties as officers of the court fearlessly without having to worry about their and their family's safety. Now we will see what are the objects of the Advocate Protection Bill of 2021. The preamble states that the bill is for the protection of the advocates and their functions in discharge of the professional duties. The main reasons for the bill is also stated to be the protection of advocates and to remove obstructions in the discharge of their duties. There are various reasons mentioned in the bill that cause obstruction in performance of the duties. And also the recent high rise in incidents of assault, kidnappings, intimidations and regular threats caused to advocates is a major reason for the cause of the bill. Where the security of the lawyers is threatened as a result of their duty, they shall be adequately safeguarded by the authorities. To protect advocates, such an act is necessary for us. It also states to ensure social security and minimum necessity for life for advocates. And also the bill came up also to implement the 8th United Nations Congress on Prevention of Crime and Treatment of Offenders, to which India was also a party in that. It was in this Congress that the basic principles on role of lawyers was also adopted. In this declaration, there are clauses that guarantee the functioning of lawyers. The clauses defines the government shall ensure the lawyers that they are able to perform all of their professional services and functions without intimidation, hindrance, harassment or improper interference. They are able to travel and to consult with their clients freely, both within their own country and abroad. And they shall not suffer or be threatened with prosecution or administrative, economic or other sanctions for any action taken in accordance with recognized professional duties, standards and ethics. Where the security of the lawyers is threatened as a result of discharging their duty, they shall be adequately safeguarded by the authorities. So, it sought to make sure that the government should protect lawyers and they are able to perform their duties. Under Section 2 of the Advocate Protection Bill of 2021, acts of violence is defined. The definition of advocate is to be the same as in that of the Advocates Act 1961. There, advocate means an advocate entered in any role under the provisions of the Act. The same section also defines acts of violence. These include all such committed against the advocates with an intent to prejudice or derail the process of impartial, fair and fearless litigation. These acts could be of threat, harassment, coercion, assault, malicious prosecution, criminal force, harm, hurt, injury, etc. like that potentially impact the living and working conditions of advocates. This also includes loss or damage of property. These offences are to be cognizable and non-bailable offences. Then punishment and compensation. Section 3 and 4 talk about the punishment and compensation in the Advocate Protection Bill of 2021. Punishment can start from 6 months and extend up to 5 years, and for subsequent offence up to 10 years. Fines start from Rs 50,000 and goes up to 1 lakh. And for subsequent offences, fines can go to Rs 10 lakh also. The bill also empowers the court to award compensation to advocates for the wrong committed against them. Next one is investigation by the officer above the rank of DSP. This defines that the investigation in these offences shall not be done by any person below the rank of Superintendent of Police and must be completed within 30 days of registration of the FIR. The bill also proposes the right of police protection to advocates upon proper investigation by the court. Next one is the important one, Redressal Committee. The next important provision in the bill is that of constituting a Redressal Committee, a 3-member committee for Redressal Committee of Grievances of Advocates and a bar associations has been provided at each level, that is District and High Court and Supreme Court. The head of this committee is to be the head of judiciary of that level, such as District Judge for District level, Chief Justice or his nominee for High Court level and CJI or his nominee for Supreme Court level. The appointment of the remaining 2 members is to be done by the nomination by the respective bar councils. The president of the Bar Council shall be the special invitee at the meetings of the Redressal Committee. Next, the important one is protection against the suits. No suit is to be instituted against a lawyer who has been working in good faith. Communications between the advocates and their clients must be respected. The confidentiality also must be protected. Next one is the protection against arrest and prosecution. Here section 11 provides that no police officer shall arrest an advocate and or an investigate a case against an advocate without the specific order of the Chief Judicial Magistrate. When the information is given to an officer in charge of a police station of a commission of any offence by an advocate, the police officer shall enter or cause to be entered the substance of information with a book to be kept by such officer and refer the information with other connected materials to the nearest Chief Judicial Magistrate, who shall hold a preliminary inquiry to the case, and Chief Judicial Magistrate only concerned shall issue notice to the advocate and give opportunity of hearing to him or to his counsel or representative. After hearing, if the CJM finds that FIR has been filed against the advocate for some malicious reasons emanating from the discharge of official duties of the advocate, then CJM shall grant bail to that advocate. Next one is Social Security. Social Security. The Act proposes that the state and central government have to make provisions to provide financial assistance to all needy advocates of the country in unforeseen situations such as natural disasters or like epidemics like COVID like that. A minimum of rupees 15,000 every month shall be provided. Presumption as to coercion in case public servant obtaining privileged communication from legal practitioner. Privileged communication means nothing, that is the protected communication that has been recognized legally. Section 12 provides that where any public servant having power of investigation or arrest under CRPC, CRPC means Criminal Procedure Code, is found in possession of or found to use in his investigation any such privileged communication or material which can be shown to be obtained from an advocate, it shall be presumed that such privileged communication or material was obtained by such public servant by coercion. If you guys really like this video, please do like, share and subscribe my channel, and don't forget to click the bell button to get notified. Thanks for watching.